Afternoon, everyone, and welcome to this WEDI Spotlight Changes to HIPAA Part 2 for Substance Abuse Disorder Consent Privacy Requirements. This is a WEDI Privacy and Security Workgroup Spotlight. It's my pleasure to introduce Leslie Bergeheiser, the WEDI's Privacy and Security Workgroup co-chair, along with Tanten Nguyen with Kaiser Permanente.
Good afternoon, everyone. Michael, can you hear me okay?
Perfect.
There we are. Hi, everybody. Thank you so much for joining today. I'm Leslie Berkeheiser with the Privacy and Security Workgroup, as Michael mentioned. My co-chair, Tantian Nugent, as well from Kaiser Permanente, and the rest of us at WEDI are thrilled that you've decided to join this discussion today regarding the changes to HIPAA Part 2 for substance abuse disorder, consent, and privacy requirements. It's quite a weighty topic and one that is very difficult. And I think as a person that's spent a lot of time in the HIPAA privacy field, I still have confusion over which components of this affect which kinds of entities, et cetera. And so I'm hoping that some of the presentation today will enlighten all of us if we have those kinds of questions. We are very privileged today to have Helen, and I'm gonna say her last name the way she told me to say it 25 years ago when I met her. Oh, she loves to ski. That's how she said I should always say it. Hi, Helen. Thank you. Who is a distinguished healthcare and data privacy attorney. She's actually local to me. I'm outside of Philly, and she's in the New Jersey, Pennsylvania area. And she advises hospitals and health systems and behavioral health providers, substance use disorder programs, data aggregators, health information exchanges, networks, health information technology companies, and just a broad range of healthcare data exchange stakeholders. She's a founding member of attorneys at Oh, she loves to ski, and she's going to fix that for me when she speaks. A progressive client focused boutique law firm known for delivering high quality, high value legal representation. She brings extensive experience guiding addiction and mental health organizations through complex and sensitive privacy laws. And I had the privilege, as mentioned, of working with her decades ago when we were implementing initial HIPAA privacy and security, and we were delivering educational sessions together. So when I was introduced to her a year or so ago, I just knew we would want to take advantage of her expertise with our privacy security work group. Helen, without further ado, I'd like to turn this over to you. I do have your slides. Just let me know if you want to work the slides or you'd like me to do it for you.
Thanks, Leslie, so much. Probably in the interest of avoiding to have to say next slide a bazillion times, if you could allow me to advance those myself, I think that probably would be most efficient. So,
Absolutely. So you just need to go to the share at the bottom in the middle
yep,
and go ahead. And I think you have permission. If not, Michael
I
can
do
help you.
now. Yep.
Thank you.
All
Um,
right.
and Tantian and I will monitor the chat, Helen. And if you're comfortable and want to take questions as we go, or if you want to wait, that's up to you. You can just let us know.
Wonderful. I just need a little bit of help knowing whether or not, let's see. I'm trying to ensure that you see a full screen. Do you see a full screen now?
No, it looks more
Oh, it
full.
was before. It was correct before.
Yes, the one before looked more
Oh,
full.
okay. Let me try this again. Darn it. My apologies. Bear with me.
Now it's a
Okay.
nice picture. Okay. And now,
Yeah,
yeah,
it's because I have a docking station. So now is it full screen?
there you are. Looks good.
Okay, excellent. Let's get going. Thank you, Leslie, and thank you to the WEDI folks for having me today. It's honestly my privilege to be here. I send all of those compliments back to Leslie. She's absolutely a leader in the field in terms of health information exchange, privacy and security, and all things related to interoperability. And it's been my pleasure to become reacquainted, as Leslie mentioned. I think from now on, I am going to pronounce my last name as Oh, she loves to ski all the time, because I think that's That's just great. It is a mnemonic that I do tell people to help explain why there are 5 consonants together without any vowels and how to pronounce that. So yeah, Oshi loves to ski is a mnemonic, but the pronunciation is Oscislawski, and it's my pleasure. We don't have that much time, and as Leslie mentioned, this is a very deep topic with a lot of details, a lot of nuances, and a lot of questions. So as I advance through the slides, I am going to be doing essentially a high level of all of the most material and important parts of 42 CFR Part 2. So as I move through the slides, I encourage you to drop in your questions if you have an experience at your organization or you're grappling with a specific nuance or a question on any of the topics as I move through. Drop them into the chat box, and hopefully we'll have a few minutes at the end to maybe have an open discussion with regard to those questions. And if for some reason we run out, I'd be happy to follow those up with an FAQ in written form to WEDI to circulate to the participants today. So without further ado, those who have been tracking 42 CFR Part 2, and to be honest, I don't know the full scope of the level of familiarity with all of you on the call today with 42 CFR Part 2. For example, earlier this week, I had 65 participant callers who are essentially 42 CFR Part 2, a substance use disorder facilities and opioid treatment facilities. So everybody was very familiar with this slide when I said it's been a long and winding road. If you are, predominantly in the HIPAA world, you may tangentially have come into contact with Part 2, but it may not be your everyday in and out existence in terms of how you deal with in the first federal privacy law you go to when you're talking about the use and disclosure of health information. But Part 2 is another federal law. It actually predates HIPAA, and there have been a number of evolutions to this federal law. You can see from my little chart here, and this is posted on my blog site called Legal HIE, where I post about all kinds of things related to the Health Information Exchange. You can see that the first iteration of 42 CFR Part 2, which is a federal law, of course, protecting the privacy of substance use disorder treatment information provided by Part 2 programs. It started back in 1975, and the concern there was with ensuring that this kind of information is not used against individuals, particularly in the legal context. That was one of the primary focuses and concerns back in 75 to avoid discrimination and any kind of use of information that could potentially be used against individuals who are going through substance use disorder treatment. So as you can see by my little pictorial here, it's gone through a number of evolutions. It was a fun little project that I embarked upon because those who are in the regulatory weeds like I am often find themselves having to go back to published preambles by the regulating agency, in this case HHS, to get some of the insights, some of the responses to public questions that have been submitted. And oftentimes I had to go fishing for the 2017 rule, the 2018 rule, the 2020 rules. There were 2 of them. And so now, for those who do go back to those preambles, you can go to my chart on my blog and have them all here. The ones that were published back in 74, 75 were particularly fun to find, and their formats were nothing short of, I think, microfiche. So it was sort of interesting. But the point here is that this went through a lot of changes. Part of why we saw that rapid fire of final rules from 2017 to 2020 is because as we moved through a sprint to coordination of care, and there was a push towards interoperability and trying to relieve information or move information for those kinds of quality benefit purposes, they were trying to align these rules that were at that point hadn't been touched in decades to the new world that we were living, and particularly the digital world. It was a challenge because the original statute that enabled the agency to promulgate rules was sort of confined to the original language, and the agency found itself restricted in terms of what it could and could not do. And they tried as best they could through, from 2017 to 2020 to free up within their constraints, their statutory constraints of what they could do, but they, it still was not ideal. The CARES Act was enacted. Congress took an actual congressional action that allowed them to now free up and allow for what we see now, which is the 2022 final rule, and what we'll be focusing on today. That congressional act freed up and allowed for things like that we're going to cover today, some of the alignment with HIPAA and other sorts of changes that are in the final rule. So this has been around for a while, the 2024 rule. It was passed almost 2 years ago, and it has become fast and furious, an important topic right now. I think we're either 70 days or maybe even at this point, less than 70 days out from February 16th, 2026. It could be less than that. So, it's definitely getting close to the compliance deadline. And when I say compliance deadline, what that means is beginning on February 16th, 2026, enforcement will begin potentially. So, and that's one of the biggest changes that happened with this rule. And I want to lead with this because I think it's important to understand that this is not just another rule that was changed. For those who have been tracking in that long winding road I just referred to, there have been changes along the way, but for all intents and purposes, nothing changed with regard to enforcement. And so those changes were occurring, but the enforcement levers that were in place during those first changes that happened from 2017 to 2020 remain the same. So on the left side of the screen, you'll see that the 1975 enforcement framework was housed in the Department of Justice at the federal level, and that was basically it. So if you violated 42 CFR Part 2, the only risk, if you will, to your organization, other than potentially reputational and setting aside whether or not you could potentially get sued under state law claims, but under 42 CFR Part 2 specifically, the only risk to you was the potential that the Department of Justice was going to come after you for criminal enforcement for violating Part 2 because you knowingly and intentionally violated the statute. Needless to say, there was essentially no enforcement. Colleagues and myself, I don't think we've heard of one case where the DOJ actually enforced for 42 CFR Part 2 during the entire time it's been in effect. And that's why this is such a critical, fundamental tectonic shift when it comes to enforcement, because starting February 16, 2026, that entire enforcement structure is now expanded 10 times fold. We're now looking at a HIPAA type enforcement, a framework for enforcement of 42 CFR Part 2. That includes the prior DOJ criminal enforcement if you were knowingly and intentionally violated, but it now is going to extend to things like compliance audits, investigations, corrective actions, resolution agreements, civil monetary penalties, and potentially civil lawsuits that are brought by state attorneys general. The criminal penalties also under HIPAA are now going to apply equally to, or similarly, I should say, to violations of 42 CFR Part 2. So in addition to the old 1975 framework where the DOJ can prosecute, there's also now the potential for the criminal provisions under HIPAA to allow for imposing of massive fines upwards of $250,000 and imprisonment of up to 10 years in cases where, say, Part 2 records or Part 2 information have been used and disclosed with the intent to sell, transfer, or use that kind of information for commercial advantage, personal gain, or malicious harm. And those sorts of terms are not to be used taken very lightly, because commercial advantage and what is considered personal gain is subject to interpretation. And so it's all to say that you need to be very careful when you're now dealing with Part 2 information with intention to sell, transfer, or use, where there's any sort of remuneration, because now we have very strong criminal provisions that could apply. All the other HIPAA style enforcement that is found in the enforcement framework for HIPAA now equally applies to Part 2. And that means that the compliance and investigations that will follow if there is a complaint filed or if there's self-reporting of breaches, much like we see with HIPAA, is going to now trigger potential OCR investigations and compliance. If they find you out of compliance, they're permitted to calculate civil monetary penalties against you. One of the questions I got on this point a couple of times is, well, what if my organization is both a 42 CFR Part 2 program that's subject to civil monetary penalties for violations of Part 2, as well as a covered entity that is subject to HIPAA civil monetary penalties if I'm violating HIPAA? Am I potentially going to be assessed, or can I potentially be assessed double civil monetary penalties for a single violation? And that is a very interesting question. What I can say about this is that the enforcement frameworks, if you will, don't expressly prohibit that sort of thing. And so at a minimum, it's possible that OCR, in calculating civil monetary penalties, can use that as possible leverage against an organization in when reaching resolution agreements to potentially perhaps enter into a higher amount resolution agreement. So it's something definitely to be mindful of. And of course, procedures for ALJs. The complaint process that is under HIPAA is now actually a new mandatory requirement and allowance under Part 2, meaning that this is actually the section of 42 CFR Part 2, the final rule, section 2.4, that requires all organizations that are Part 2 programs to allow any person to file a complaint against you to the secretary for violation of 42 CFR Part 2 by a Part 2 program or a qualified service organization or a lawful holder or so on. And you cannot retaliate or intimidate against such people or any person. It can be a patient, it can be an employee, it can be a family member, it can be a third party, it can be a competitor to you. There is no restriction on who can file a complaint. And there is actually a website. This is the OCR complaint portal. It currently accepts complaints. As you can look down, if you look past item number 3, it currently accepts complaints for violations of civil rights, religious freedom, and you can see the third bullet here you can click is for filing violations for privacy and security of HIPAA. I suspect that this will be updated come February 16, 2026. That will allow potentially a fourth button that says violations of privacy or security under 42 CFR Part 2, which will allow for that complaint process to extend to Part 2 violations where people can file those. And if that happens, what happens? Typically, OCR, so we know as of several weeks ago at this point, Secretary Kennedy announced officially that the agency that will be enforcing compliance with 42 CFR Part 2 will be OCR, Office of Civil Rights. That is the same agency that is currently enforcing HIPAA. And I think 2 weeks ago or so, I saw a notice come through, a posting that they're hiring new attorneys. And the posting and the job description specified that the attorneys that they will be hiring are going to be responsible for a number of enforcement, including 42 CFR Part 2. So they are definitely ramping up, and this is real. Adding attorneys, adding resources, providing the mechanisms. So this is something definitely, and if a complaint is filed, it's reviewed. Some complaints are not worthy of any further investigation. They may be closed if they find, if OCR finds based on the facts and circumstances, there actually is no question of fact with regard to the complaint. But if there is a question of fact, the next step typically will be to write a nice little letter to the organization against whom or against which the complaint was filed and say, hey, we received the complaint. What say you? And I've been on the receiving end of numerous numbers of those on the HIPAA end. So we can expect those to begin after February 16th, 2026. The other thing we need to be mindful of is that this is also brand new, never before, under section 2.3 of Part 2. It's extending the authority to bring actions for Part 2 violations, and they're giving the authority to state attorneys general. So if you're in a state like New Jersey, which is a state where I practice most predominantly, the attorney general has been quite active, quite frankly, in enforcing HIPAA violations. And so, we should be ready to anticipate that same similar kind of activity could be taken up by state attorneys generals once they get that new quiver to be able to enforce for privacy violations of Part 2, since that statutory authority has now been granted to them. So the first question at your organization, so now we understand the enforcement, and let's get into now kind of evaluating the new framework and the new world we're in. And it really starts with having to evaluate who does the Part 2 law apply to, because it does not apply to everyone. Like HIPAA and its covered entities, so we know that HIPAA doesn't apply to all providers. It applies to most providers because they're engaged in electronic standard transactions in connection with the healthcare services they provide. Part 2 does not apply to all providers. You actually have to be a program or a provider that is federally assisted and fits the definition of what is a program under Part 2. And you also have to be able to identify the patient, so as having substance use disorder information. So with regard to the federally assisted, if your organization is a freestanding substance use disorder treatment facility and you are receiving any federal funds, Medicare, matching Medicaid, any sort of funds, quite frankly, you don't have to necessarily be using those funds, any of the funds or all of the funds for substance use disorder. So long as you're receiving federal funds, it meets that prong of the test, if you will. So then you just have to answer the question of whether or not you constitute a Part 2 program or not. Okay, so a program can mean a couple different things. It could be actually a person other than a general medical facility who holds itself out as providing or provides substance use disorder diagnosis, treatment, or referral for treatment. Or it could be an identified unit within a general medical facility that holds itself out as providing SUD diagnosis, treatment, referral for treatment. Or it could be medical personnel other than staff in a general medical facility whose primary function is the provision of SUD diagnosis, treatment, or referral, and who is identified as such a provider type. So a couple of examples of what a program would be. The easiest one, obviously, is a freestanding. If you are a freestanding SUD, substance use disorder treatment provider program, even if you provide behavioral health as an ancillary service or a secondary service or a tangential service, the fact that if you're providing SUD and that is a primary function of what you do, and you're freestanding and you're accepting Medicare or any kind of federal dollars in connection with those services, then you are a Part 2 program, and the identifiable Part 2 information you generate as part of those services and part of those activities would be subject to 42 CFR Part 2. So that's an easy one. The larger healthcare system. So you have a healthcare system, you have a unit, the unit is designated, the unit provides SUD / maybe behavioral health, and everybody who receives services in that unit is receiving services for simply those, for those reasons, for SUD services. And you're receiving, as a larger organization, federal dollars, and therefore the identified unit is required to comply with 42 CFR Part 2. An emergency room who is accepting patients into the emergency room, seeing a lot of overdoses, treating overdoses, detoxing, whatever. That is not subject to Part 2. Well, what if 90% of my population is coming in for drug-related issues? Don't matter. You're an emergency room. It is not the primary function of what an emergency room does, unless you are an emergency department that is tacked on specifically for an SUD provider program, that you are fielding solely SUD detoxes, so on and so forth. But a general EMTALA-based emergency room is not a Part 2 program, even if a lot of the people come through there are potentially experiencing substance use disorder. It does not subject those patients, nor the records, nor the information that's generated in the emergency department to 42 CFR Part 2. There is a caveat. person comes in and you now ED director, ED attending now refers to your SUD unit, and clinical social worker who is a designated medical personnel from your SUD unit now comes over to the ED department and does a referral and a consultation for a referral to potentially inpatient and to admit the patient into the SUD designated unit program. That assessment by that designated personnel, if he or she's primary function is the provision of SUD diagnosis, treatment, or referral, and they're coming for that exact purpose, and that is what they are solely what they're doing, and that's their predominant function, then that episode and assessment would be subject to part 2, and you would need to figure out how to either lock that down or capture consent for that upon that interaction. There are a couple of other scenarios that there's a myriad of scenarios, like in the there are programs sometimes run in the prison systems, correctional facility systems, as well as community programs. And the guidance or the what I have to say about that is you need to take a look at those carefully. And as I said, step 1 is defining very clearly which one of those programs and how those programs fit under 42 CFR Part 2, so you know clearly what your obligations are. There are a number of exceptions of organizations and entities that do not have to comply with 42 CFR Part 2, like the Department of Veterans Affairs, communications with a parent org. So like, for example, if you're in a healthcare system or part of a healthcare system and you have a parent organization that in itself is not the SUD program, but it serves as it serves as having direct administrative control. It provides supportive services like legal and other executive functions to the SUD program. Then you would not necessarily consider that to be part of the program, but certain communications can go back and forth between the parent and the SUD program. Also, qualified service organizations, referred to as QSOs, are not directly subject to Part 2 unless they are actually being provided Part 2 information, and so then you need a written agreement in place with the Part 2 program, and that will allow those communications to go back and forth without any consent, so long as it stays within the confines of the actual written agreement. What is a qualified service organization is very important to take a look. So step 1, we went through assess where your Part 2 programs are and where are you generating Part 2 records and information. Step 2, I would say, is you need to evaluate who your vendors are for your Part 2 programs and identify who they are, of course, making sure you get the documentation in place, but the key here, I think, what I always say is you need to understand whether or not a vendor truly qualifies as a qualified service organization, otherwise referred to as a QSO, because that is a definition. It is true that many qualified service organizations are also HIPAA business associates, if you happen to also be a covered entity, but they're not completely interchangeable, in the sense that the services actually have to be provided to the Part 2 program, and they're limited to a list. Things like data processing, billing collection, dosage preparation, laboratory analysis, legal, accounting, pop health management, medical staffing, other professional services, or other sorts of services to prevent child abuse, neglect, including training on nutrition, childcare, so on and so forth. So, and the key is that qualified service organization has to be performing a function or service on behalf of the Part 2 program, not on behalf of a third party, not on behalf of its own benefit or its own commercial gain or its own commercial purposes. The services need to be provided on behalf of the Part 2 program. And in order to provide the services, the QSO needs access to or a copy of the Part 2 information in order to be able to perform those services. Okay, they did make it clear that business associates are included in that, within that definition, so long as it meets the other criteria. What I see all too often, and is what very concerning, is and this happens actually with HIPAA and BAAs as well, is that information is simply decided that it's going to be shared with a third party because there's some sort of programmatic or other benefit that has been determined to that arrangement. And people like to slap a BAA or a QSO agreement on that to make it okay. The putting in place of a QSO agreement slash BAA agreement on top of a data sharing arrangement with a vendor does not bless or make the data sharing legal. The legality of whether or not the information can be shared with the QSO and then thereby a written agreement needs to be put in place is the nature of why the information is being shared and whether the services are being provided on behalf of the Part 2. You have to look at the functional definition first in order to determine whether it's permissible as per under the Part 2 definitions. And then once you determine it is permissible, then the QSO agreement slash BAA is a procedural requirement that needs to be in place to make sure that it's documented and okay under Part 2 in terms of those requirements. The other type of individual or entity or bucket of recipients that could become subject to Part 2 are referred to as lawful holders. And lawful holders are any person, and when I say person, I mean person, individual, or entity who is bound by Part 2 because they've received Part 2 records as a result of getting that pursuant to a consent that's been signed, that is a Part 2 consent, or pursuant to an exception to the written consent under Part 2, which doesn't require consent. The point is that somebody or something has received Part 2 records and they've received that lawfully because somebody has consented to them receiving that, or there's an exception to consent, and now they've become a lawful holder. Well, so what? Now what? What if I'm not a Part 2 program, I've received that Part 2 records? What are my responsibilities? And it depends. It depends on the type of written consent that you receive the information pursuant to. So if you are a lawful holder, like a covered entity, and you've received Part 2 information pursuant to a TPO consent, you may be able to use and disclose that information largely in accordance with and in alignment with HIPAA. There are two exceptions. Exception number one is if the patient revokes that TPO consent, you now have to stop using that Part 2 data. And number two exception is if there's a request for law enforcement purposes or legal proceedings against the individual, you cannot release that Part 2 information as a lawful holder except in accordance with Part 2, not in accordance with HIPAA, in accordance with Part 2, which almost always requires a court order. So that is really important to understand which bucket you fall into. Most of you on the call will fall into column number 1, which is Part 2 programs, and all of the key compliance requirements that flow to you, which means full P&Ps, QSO agreements, bound fully by the Part 2 regulations. If you are a QSO agreement, which is the middle column, which maybe some of you actually on here are, if you're vendors, then you need to understand that the way you receive information and then how you can subsequently use that information does not always align with HIPAA. So if you are accepting Part 2 information from a Part 2 program and you are identifying as a qualified service organization and doing so, you cannot make the mistake of treating that information in accordance with HIPAA because there are very, very clear distinctions in how you must treat that information. And you need to understand those and make sure that you're compliant in treating. One of those examples I will highlight here is, for example, under HIPAA, a business associate is typically allowed to simply contract and subdelegate many things to a subcontractor without having to take any further action. And they simply need to have a subcontractor agreement that has similar provisions to what is found in the primary BA between it and the covered entity. SAMHSA, which is the agency under HHS that promulgated the final rule in 42 CFR Part 2, refused or declined to extend that same framework to QSO agreements, to QSO organizations. So what that means is if you are delegating certain services that you're performing on behalf of a Part 2 program to a third party vendor, i.e. a subcontractor, you have only two choices. Number one, either it has to be consented to, so either a TPO consent or an adequate consent of some sort covers that sort of disclosure, Or number two, SAMHSA is essentially going to treat that and you need to be prepared to treat that subcontractor as your agent. And as you know, from a legal perspective, if you talk to legal, that can raise a whole host of liability allocation questions, because you essentially will become responsible for the acts and omissions of the subcontractor as if they were your own. Lawful holders, the last bucket, has the fewest compliance obligations, but there are still some. And so if you are receiving Part 2 information in a capacity other than being a Part 2 program or a QSO, there are certain things that you still need to do and certain things you need to abide by. The most confusing or the most tricky of which is whether or not you're receiving information pursuant to a TPO consent, and you can then thereby largely use and disclose and redisclose that information in accordance with HIPAA, or are you receiving that pursuant to a different kind of consent? A Part 2 consent that says you can receive information only for example, for research purposes or for public health purposes, that's not a TPO consent, then that means that once you receive the law as a lawful holder that information in your capacity for public health purposes or research purposes, you cannot redisclose and reuse that information in accordance with HIPAA. You are confined to only using and disclosing that information for purposes of the primary purpose of research or public health. And then if you want to redisclose, you either need to get consent, or that's it. You need to abide by HIPAA and cannot you need to abide by Part 2 and you cannot redisclose that information. Okay, so moving on to what is it applied to? Of course, it applies to records. This is essentially going to be anything that the Part 2 program creates, receives, or acquires during the provision of SUD treatment, referral, or diagnosis. So it's essentially anything that's created and it originates from a Part 2 program. Unless you are a lawful holder and you're receiving that information from a Part 2 program, that still retains its status as Part 2 information. We were hoping, or I guess, one of the struggles with interoperability and data sharing in the Part 2 realm is that historically Part 2 information has always retained its required restrictions on redisclosure. And so when it was taken in either by a health information exchange or a healthcare system that is not typically operating under Part 2 principles, it became challenging. And there was a lot of concern about, do I segregate the data? How do I segregate the data? How do I whatever? And by large part, if some of that has been removed, if you're able to get that information to you under a TPO consent now, but if it's not coming to you under a TPO consent, then the segregation, the practical implications of having to segregate that Part 2 information as a lawful holder are still remain. And that's the truth of it. While SAMHSA made an effort to say segregation is not required, we're not requiring segregation, that's great, except practically speaking, there's no way to meet the requirements unless you're able to identify the Part 2 records, part of your larger record pool, and be able to do what you need to do with it in order to comply with Part 2 if you're not segregating it, or at least somehow tagging it by an identifier that can tell you that the source is a Part 2 program. So then if you need to either lock it down or prevent it from being aggregated or commingled with other records, you can do that. Another provision in terms of what does it apply to is de-identification. Up until this point, there was no Part 2 de-identification standard. And it relied on the fact that Part 2 records were those which were identifiable and relate to an individual getting SUD treatment, diagnosis, or referral. And so the reliance was solely, and interpretation was solely on that identifiable information, which had quite a bit of wiggle room in terms of what is considered not identifiable. And since Part 2 didn't have a very strict de-identification standard like HIPAA, often that identifiable standard was used to allow Part 2 programs to disclose certain kinds of sets of information, either for public health purposes or for other research purposes, without having to necessarily meet the strict requirements of HIPAA if they didn't otherwise have to. That has now gone away, and Part 2 is fully aligned with HIPAA. So what does that mean? It means that the personal interpretation of what is identifiable no longer applies. There is no room for interpretation. It is now adopting a full de-identified or not legally de-identified or not legally de-identified. And that means, of course, for those who are familiar with de-identification under HIPAA standards, it means stripping out all those 19 identifiers or having an expert determination to render it considered fully de-identified. And if it's not fully de-identified, then it is considered still identifiable and therefore subject to all of the full suite of Part 2 restrictions. This materially affects some disclosures that Part 2 programs have been making for research and public health purposes, because now it has to meet any of those disclosures for those two types of purposes, where historically the kind of data sets that may have been shared by Part 2 programs for those kinds of purposes, where they were believed to be adequately not identifiable under the old standard, may now not meet that standard, because now we're imposing the full de-identification of HIPAA onto that. So those need to be reevaluated. There is an exclusion for verbally spoken. So, for example, SUD provider calls another part of your healthcare system because a patient's been transferred and admitted into inpatient because of non-SUD or otherwise clinical conditions, and they have a conversation. Yes, person was getting XYZ medication or yada, yada, yada with treatment for SUD, and they share that with the attending on the inpatient floor, and the inpatient attending reduces that into the EHR. That does not constitute, and you do not have to treat that under Part 2 for whatever it's worth. They reduce that into the new final rule. And there is now a new provision for SUD counseling notes. This is a new protective standard for a very specific subset of information in substance use disorder treatment scenarios. And it is most likely akin to psychotherapy notes, as we're familiar with on the HIPAA end. This has very low application to the EHR. Generally, this is going to be an actual, like a psychotherapy note, well, a similar kind of counseling note, but in the substance use disorder realm, that's being reduced into that little black book of the psychologist, psychiatrist, or clinical social worker. It's what their impressions that they're taking down during that one-to-one session. They made it clear what the final rule, we're not talking about medication prescriptions and monitoring, counseling sessions, stop times, modalities and frequencies of treatment furnished, results of clinical tests, any summary of the following items: diagnosis, functional status, treatment plan, symptoms, prognosis, or prognosis of date. It's really the reduced little black book of the psychotherapist, similar to the psychotherapy notes. There are applications out there that have the clinicians reducing that and are separated out from the general EHR, but just understand that if you do have clinicians who are documenting counseling notes or of this nature, that they're subject to a higher standard in terms of consenting and require, quite frankly, their own specific consent to this group of type of information before they can be released in any way, shape, or form. Next, I want to touch on breaches because this is another seismic shift in Part 2. Before this final rule and before it goes into full effect on February 16, 2026, there was no formal security standard or requirement to notify patients of an unauthorized disclosure of Part 2 information in violation of Part 2. There has been, I think, some confusion on this because I often get the reaction, well, we've already been notifying because we have to do that under HIPAA. Okay, yes, if you are a Part 2 program and you are also a HIPAA covered entity, then certainly if you have an incident, a security incident or other sort of event that results in the unauthorized use and disclosure of PHI, which is also a Part 2 record or happens to also be a Part 2 record, then yeah, you would have had to report that based on your HIPAA analysis of whether or not that is a reportable breach. But there was nothing that was independently requiring you to notify anybody if some sort of use and disclosure was a violation potentially of Part 2 when it wasn't a violation of HIPAA. And let me give you an example of when that could come up. Let's say that you had an API feed that was feeding Part 2 data, and the Part 2 data was being fed into a data exchange for treatment purposes. And that was the sole purpose for why that information was being fed, for coordination of care for treatment of the patient. And the Part 2 program was collecting consent and whatnot, and sending that information based on the use case of treatment purposes. It was, let's just say hypothetically, it was discovered that for some reason that the consent were not being collected. Consents were not being collected for treatment. For some reason, there was a lapse, and 2 weeks worth of consents were not collected. But all of the Part 2 data was still being transmitted to the data exchange and was still being shared with other treating providers for treatment purposes. So is that a breach? Well, under HIPAA, it's not, because the Part 2 program, to the extent that it's a covered entity and did not collect a consent to release that Part 2 information or that PHI through the network exchange to other providers for treatment purposes, it doesn't matter there was no consent collected, because under HIPAA, a consent is not required. Information like that can be shared for treatment purposes, and therefore there is no unauthorized use or disclosure of PHI under HIPAA's breach analysis. However, that same exact scenario, because a consent was not collected, and because Part 2 does not have a broad exception allowing for Part 2 information to be shared in a blanket manner for treatment purposes in the same way that HIPAA does, a consent is required. And therefore, that same exact scenario in the release of that information through a network for treatment purposes, where 2 weeks worth of consents were not collected, is actually an unauthorized use and disclosure of Part 2 information in violation of Part 2. Now, up until this point, there was no obligation to tell anybody about that because there was no breach notification provision under Part 2. So you fix it and we go about our merry way. February 16th, 2026, that same exact scenario is now potentially reportable. So the same provisions that are under HIPAA would apply here. You would need to potentially notify individuals, media, secretary. There could be law enforcement delay. I will say that lawful holders and QSOs are excluded for notifying regarding breaches. This was a purposeful exclusion that SAMHSA pointed out, and they said, we can't do this because we don't have the statutory authority to extend our requirements to lawful holders and QSO. But we expect that if you're going to be contracting, you being a Part 2 program, we're going to be contracting a vendor to handle your sensitive Part 2 information, that you're going to be getting them to agree to notify you of Part 2 breaches in the same way that they would be notifying you of HIPAA breaches. I will tell you, I've had at least one instance so far of a vendor saying, I'm not signing that because I don't have to, which is technically true. The next question is, do you want to work with a vendor who's refusing to abide by Part 2's requirements in good faith? Is that the kind of a vendor that you want to partner with as a Part 2 program if they're not willing to notify you of potential breaches of Part 2? So I leave that question as an open question. But the point being is there is no statutory or regulatory independent basis for a qualified service organization to notify Part 2 programs if they are the source of the breach of Part 2 information, unless you bake that straight into your BAA/QSO agreement with that vendor. So things that you want to definitely do here is make sure that you have a breach assessment tool set up. Like this is one that we have on our Legal HIE website, walking you through and making sure you're evaluating all of the regulatory requirements. And you definitely want to update your policies, procedures, prepare your incident response team, and train your workforce. Remember that both the assessment and the PMPs, they all need to be updated because of that example I just gave you. Historically, a situation like that would not require any kind of reporting. where consents were not required were not obtained or collected for whatever reason for treatment. But now, starting in February 16th, that situation would have to get assessed, evaluated, and a determination would have to be made whether there was any obligation to legally report to individual or others. Okay, moving to consent real quick. Of course, consent, generally speaking, for 42 CFR Part 2 is almost always required prior to any disclosure or sharing of any Part 2 information identifying the patient as being or having been diagnosed with substance use disorder, a substance use disorder, having or having had substance use disorder, or having been referred for treatment for substance use disorder. It's quite broad, and it is basically the baseline. You cannot have a thinking of, oh, I'm just going to follow HIPAA, because Part 2 truly is different. It has exceptions to consent, and they are ones that you can avail yourself of. They are, to some extent, they do overlap with HIPAA. In other cases, they diverge from HIPAA in that they are slightly more restrictive or require you to meet certain additional criteria, as is the case, for example, with law enforcement and court orders. You cannot follow HIPAA's law enforcement and court order and criminal justice provisions to satisfy Part 2. You would have to meet the more stringent criteria and narrower exception to allow for sharing of Part 2 information for those kinds of purposes pursuant to those exceptions. Similarly, with public health authority as well, under Part 2, the information now needs to be fully de-identified in order to be transmitted to a public health authority, or otherwise you're going to need to bake in consent language into your consents, allowing certain information, data elements to be shared with public health authorities in that way. There is no exception for treatment. There is no exception for payment. There is no exception for healthcare operations, and there isn't an exception for required by law. So, the way organizations are handling this is that they are revisiting their registration consent forms with their Part 2 programs, anticipating with an understanding of what their typical kinds of disclosure needs are, and baking in the consents that they need in order to get what they need done with those consent forms out of the gate. The consent elements are very specific. The biggest change here is the first one highlighted is the recipient name or description. You no longer actually have to name the recipient by name. You can say a class of persons. So all of my health plans who are paying for my services, all of my treating providers who are involved in my treatment and care. You also, that is probably the single biggest change to the Part 2 consent elements. So this significantly aligns the consent with HIPAA and allows for a much easier time to be able to capture the consent in a way that doesn't require you having to recapture it if the recipient changes, which is what was historically the real challenge. There is one really, really cumbersome requirement that when you, that is new, it's under 2.32, that when you send Part 2 information and it's being sent pursuant to a consent, you have to notify the recipient that 42 CFR Part 2 prohibits unauthorized use or disclosure of these records. You can put that right into the consent or the consent module that you're using. That usually travels with it. And then each disclosure of the Part 2 information has to either be accompanied by a copy of the consent, or it has to be accompanied by a clear explanation of the scope. So if you're using a consent module, the scope would have to drop down and say, you're receiving this Part 2 information for treatment purposes, or you're receiving it for public health purposes, or you're receiving it for research purposes, or whatever the case is. The point is that recipient has to be on notice what is the scope of the consent and what they can use the Part 2 information for. There is the brand new TPO consent that I have alluded to, and this is related to but separate from the general Part 2 consent, in that if a recipient receives Part 2 information and the patient has consented to their Part 2 information being shared for treatment, payment, healthcare operation, that covered entity may now use, and for the most part, use and redisclose that information in accordance with HIPAA. This only applies if the recipient of the Part 2 information is a covered entity, okay? And there are distinctive consent elements that go into a TPO consent. You can still use a descriptive name, my treating providers, health plans, and people helping to operate this program. You can say for the purpose, things like for treatment, payment, and healthcare operations, that is acceptable. None is allowed as an expiration of that, and there is a required TPO statement. Two statements. One, you have to include a statement or a field that says Part 2 records may be subject to redisclosure by the recipient and no longer protected by 42 CFR Part 2. That is only true if this recipient is a covered entity, and this statement actually is. I'm not going to get into it, but there's a little bit of it's confusing because it's not completely accurate, but that's on SAMHSA. And number two, you have to tell them what the repercussions are if you refuse to sign the consent. There are a number of organizations that are looking to align their treatment consents with a TPO consent. So you'll need to take a look at your consent forms, structure them, making sure you understand what the purposes are and get those all baked in, and this chart can help you do that. The last thing, in just a minute, on patient rights, some of them we've already indirectly touched on, obviously. So the first is that patients now have an express right to request restrictions on disclosures of their Part 2 information for TPO purposes and to restrict the disclosures to health plans for those who have been paid by, in full by patients. That's similar to HIPAA. And they have a right to receive an accounting of disclosures of their Part 2 information made with consent for the past 3 years, plus disclosures for TPO through an EHR. Unclear how that's going to be satisfied, whether audit logs can sufficiently satisfy that. Again, a conversation you need to be having with your vendor to make sure you can meet that requirement. The point is that's all going to need to get baked into your privacy practices notices. And of course, under breach notification, the patients have now a patient and an express right to receive notice if their Part 2 information has been used or disclosed in a manner unauthorized under 42 CFR Part 2. And you still have until February 16, 2026 to get those privacy notices updated. Make sure that they reflect those new requirements and those new rights that the patients have, and align those in your privacy notices. And here's a copy of a checklist that we've done to help organizations do that. So I think I made it with 2 minutes to spare.
Absolutely amazing, Helen. Incredible. I'm going to give you just a second to take a look at the questions in the chat. And while you do that, I'm just going to update everybody to wish everybody a happy holiday. I'm going to still give you a minute or two to finish out and see if you want to answer anything else here, Helen. But also to tell everybody that we do have our regularly scheduled meeting for January. And in February, we have Chantel Borzola from the RCE, from the Sequoia Project, coming in to talk to us about this kind of data and moving it around in the interoperability space, and some proposals they have made. So wishing everybody happy holidays, and a great big thank you to Helen, in case we run over and some people drop. But Helen, please do go ahead and see if there's anything else you'd like to share based on the chat now.
Well, okay, so I'm going to go from the bottom up.
Okay.
So number one, checklist I can share with WEDI. That's something that I posted on social media. You can slide slides. Yes. Okay. You already answered that. Mari, hi. Sharing for awareness. I'm hearing confirmation that turning off HIEs is the only restriction request that a provider could accommodate per the patient's right to request a restriction on TPO consent. This should be kept in mind if orgs are considering making the TPO ROI a requirement. So that's a comment more than a question. Okay, do you have any NPPs to refer us to? Again, I can, or look at used by entities as lawful holders, Part 2 elements. That's a great question. So the NPPs that I have are actually tailored for the Part 2 program, but you're right, lawful holders probably need to address those too, and I do not have a template for that. Mari, does anyone know if clearinghouses and payers are sharing info about how to scope the consent, TPO versus traditional Part 2 ROI consent? will move during billing to meet the requirements that the copy of the request for information or scope of the consent travels with the Part 2 info at the time of disclosure. My read is that this applies to each disclosure. That is correct, Mari. It applies to each disclosure, whether TPO or traditional, more limited Part 2 request for information revenue cycle prior auth bills have lots of disclosures. That's an interesting question, and you're right that the regulatory language does say with each, it's expressly says with each disclosure. And I will say that there's a lot of, my partner and I and a lot of colleagues have mulled, as you get into deeper weeds of the Part 2, there are a lot of unanswered questions. And this is a good one. How exact, the other one is, one that's come up is, there are some that are suggesting that the TPO consent cannot be combined with any other consent for any other purpose. There's actually a SAMHSA endorsed organization that's holding that interpretation out, that it has to be a standalone form. We have found no provision in the rule or in the preamble that actually requires that. And in fact, they expressly say that SUD counseling notes have to be captured in a completely separate and cannot be combined. They expressly say that, but they do not say that with regard to TPO. So for many of our customers and clients, we found that, operationally speaking, they have to they're not going to get multiple forms. And when you say you can't combine it in one form, what exactly does that mean? So long as it is a separate consent for TPO and separate, there's nothing that would prohibit you from combining that in one form or in one tool, if you will, in our legal reads for those kinds of things. So that's the combining question. The traveling, the notice provision. The other question is, like, once the consent goes to the primary recipient, the lawful holder, does that lawful holder now in turn have to only use and disclose that information with further notice, with those further notices traveling if they're not a covered entity? And there's conflicting guidance in the preamble and in the regulatory rule on that front. So this is another one, whether it does say each disclosure. That's exactly right. How do you operationalize that? I have no idea. It's a question, and we're hoping that SAMHSA is going to actually release maybe some more FAQs and guidance. There is a website called Centers of Excellence for PHI. It is a SAMHSA grant-funded organization. The people who have put the Part 2 resources up on that website are from Legal Action Center, which has put out a number of guidance on Part 2 in the past. They're a nonprofit organization. Like I said, it's not an official government site in the sense that it's not SAMHSA, but it says, like, all over the website, SAMHSA, it's SAMHSA funded. So it's about as official as we have now in that sense. So we're hoping that some more FAQs are going to come out. There are some up there. One of them is incorrect, though. It's just an incorrect interpretation. So for whatever that's worth. What else? Checklist sharing. Yeah, that's it. So I don't see any other questions. I don't know how, Mari always asks those hard questions. It's good though.
Thank you so much for tackling them. This was fantastic. Absolutely, as Mari mentions, and we really can't thank you enough for all of your work here and your help with the checklist, etc. And I'll make sure that your bio and information is also distributed along with the PowerPoint for everyone if they need to contact you for further assistance, Helen. Thank you so much, everyone, and happy holidays to everyone.
All right. Thank you. Bye-bye.
Thank you. Take care.